Okay. Oh, shit. It's talking about he did file it. Files a sex offender civil management petition. The respondent, within 10 days, may file a notice of removal. Now, I went over this detail in the other one, so I'm not going to belabor the point. It's 10 days after the filing of the petition. The respondent can file the notice of removal. The Attorney General can make a motion within 5 days after he gets served with the notice of removal. Next, within 30 days after the petition is filed, the Supreme Court or the county court shall conduct a hearing without a jury. It's the probable cause hearing here. So 30 days for the sex offender probable cause hearing. This is not looking for confinement versus super intense supervision. This is only a probable cause to believe that the respondent is a sex offender requiring civil management. Now, move on to 10.07. This is the within 60 days after the court determines there's probable cause, the court shall conduct a 12-person jury trial. And the issue for the jury is to determine whether the respondent is a detained sex offender who suffers from a mental abnormality. Now, that is the actual definition of a sex offender requiring civil management, right? But it's to make it clear that the court is going to decide whether or not he requires the civil management, if he needs the confinement or the strict and intense supervision. Note, during the trial, the respondent may not subpoena victims of their underlying sex offenses without leave of court. So, yeah, you have to get leave of court for that, and it's got to be on good cause. And I, again, in one of the other videos, beat the jury trial thing to death, so I'm not going to do it again. 10.07, subdivision D, which, if any of the following are true concerning the trial described in question 9. 1. A jury trial may be waived. Burden of proof is on Attorney General. Case must be proved by clear and convincing evidence. Jury's finding must be unanimous by all 12 jurors. At the trial, either party may request sealing of papers for good cause shown or closure of the courtroom. Now that is really interesting because we have open courtrooms in this state, okay? Public hearing. But it says, for good cause shown, either party, the Attorney General or the respondent, can request closure of the courtroom or sealing of papers. The commissioner shall provide the respondent and his counsel with an annual notice of the right to petition the court for discharge. Okay, now, 10.09, this says the court shall hold an evidentiary hearing as to the retention of the respondent within 45 days if it appears from one of the annual notices that the respondent has not affirmatively waived the right to petition for discharge, okay? So let me make this very clear. There is no time rule in this. There's no time rule for the respondent, but it says for the court, within 45 days, they have to hold an evidentiary hearing, because when they send the notice to the respondent in the secure hospital or whatever, it's gonna have on it, on the thing, a notice that, like a waiver form, where he could fill it out, and if he's really not interested in getting out for some reason, or having a hearing, which he maybe figures he's gonna lose at the hearing, so he doesn't want to do it, he's gotta fill out that waiver thing and affirmatively waive the right to petition. And if he doesn't, then the court has to hold this hearing within 45 days. Either he did petition the court or has not affirmatively waived the right to petition. The Attorney General may, in the appellate division of the Supreme Court, the Attorney General may, in the appellate division of the Supreme Court, seek a stay of any order under this article, releasing a person. So if the court wants to release a person for some reason and the Attorney General is like, wait a minute, that guy's gonna go rape a bunch of people, they can just seek a stay in the appellate division. Saying, oh, well, if it was county court, you could go to Supreme. No, just county court or Supreme, whichever judge it was, you're going to the appellate division. So if the county court judge releases the person, the attorney general still goes to the appellate division. Both the attorney general and the respondent may appeal